I think that Director Ratsunaya should start, and basically then I will just also make a small introduction on behalf of the SWPS University.
Okay, that was an unexpected pleasure. Thank you, Adam. But yes, my name is Ieva Raatanaam. I'm Director of Riga Graduate School of Law, and I am very glad and pleased to welcome everyone to the second webinar of the joint project of SWPS University in Poland and Riga Graduate School of Law, Spring with Law in Central and Eastern Europe. And we have the series of webinars, 4 webinars, March, April, May, and June. And we also are part of the project is to continue each of the webinar also with an interview conducted by the students of RGSL with each of the distinguished speakers of all of the webinars. And actually, as of today, right today, we issued the interview is available with Professor Martin Krieger from our first and opening webinar. It is already available on Spotify and will be published today also on video. And so I very much encourage you to follow that. So with that, I welcome you all. So Adam, the floor is yours.
Ladies and gentlemen, it is my particular pleasure to welcome you at the second webinar organized jointly by the SWPS University of Social Sciences and Humanities in Warsaw, the Faculty of Law, and with the Riga Graduate School of Law. As it was said, it is our joint project, and basically we aim towards organizing all together for webinars during the spring period. So this time we will talk mostly about the rule of law stemming from the ECHR jurisprudence. Our next meeting organized in the last Thursday of May will be devoted to the EU law and rule of law. I think this is a high topic and it will have a chance to discuss all different current and upcoming developments in the context of the rule of law. But ladies and gentlemen, today's meeting is of special importance to all of us because we have a extremely high level and distinguished guest, Professor Angelika Nussberger from the University of Cologne. But Professor Nussberger is with us because she's a former judge of the European Court of Human Rights, a very distinguished judge, not just because of the position, but because of the quality of judgments, dissenting opinions presented, and I would say like the continuation of this great European Court of Human Rights being the conscience of Europe in terms of shaping standards. I think the expertise of Professor Nussberger is well known to people, especially from Central and Eastern Europe. I had a pleasure to meet Professor Nussberger at all different occasions in my academic and professional capacity. And I would like to add also that Professor Nussberger is a member of the Venice Commission. And also, which is quite an interesting story because I think not everybody knows that the Constitutional Court of Bosnia and Herzegovina has a possibility or has a more or less like a constitutional tradition that it has international judges of this court. So Professor Nussberger is a judge in the Constitutional Court of Bosnia and Herzegovina, and in this capacity, Professor Nussberger is contributing to shaping the constitutional landscape of this beautiful country. And we have decided that today we should discuss the issue of the rule of law from the point of view of the definition of justice, and especially in the context of this definition of justice, which is more or less created by the approach towards the rule of law concept in the jurisprudence of the European Court of Human Rights. We know that there are a lot of things happening in the Strasbourg Court these days. Also, and that we observe some reflection in the ECHR coming from the Polish cases, Polish problems, but also Icelandic case was decided quite recently. But we have also there were a number of important cases decided over last years, such like great judgments like Baka against Hungary, or Alexander Volkov against Ukraine, or Kudeshkina against Russia. So I think the court in Strasbourg is getting more and more closer into the discussion on what is really the definition of the rule of law and what is the value of the institutional safeguards for the protection of human rights. So I do hope that Professor Nussberger will share some views concerning this. And following the keynote speech by Professor Nussberger, we'll listen to two comments by Dr. Barbara Grabowska-Moros from the Democracy Institute of the Central European University in Budapest. So this Democracy Institute, and I would like to underline it, is based in Budapest, not in Vienna. And Barbara Grabowska-Moros is working there. And by Mr. Kristaps Tamus, who is affiliated with the Constitutional Court of Latvia and also with the Riga Graduate School of Law. So following the keynote speech by Professor Nussberger, we'll listen to short comments of our speakers. And thereafter, I would like to encourage all participants to be active in our discussion. I will do my best in order to aggregate a couple of questions. I think that last time with Professor Martin Krygier, we had a really intensive discussion. So I think Professor Nussberger should be prepared for answering a couple of those questions. So without further delay, I would like to give the floor to Professor Nussberger, and I would like to thank you very much for your for agreeing to participate in this event. Thank you very much.
Dear Emma, dear Adam, dear colleagues, thank you so much for this invitation. We're talking about a joint project, Polish-Latvian, and I'm very happy to be sort of integrated today into this joint project, coming from Cologne now and being integrated in our new virtual world. You asked me to speak about rule of law, and I have given it the title, Rule of Law, Clarities and Unclarities about the fundamental notion of justice. Let me start by a quotation. So I quote, "In a world divided by differences of nationality, race, color, religion, and wealth, the rule of law is one of the greatest unifying factors, perhaps the greatest, the nearest we are likely to approach to a universal secular religion." So these are the words of Lord Bingham. And whenever you mention the notion of rule of law, I think the name Lord Bingham is not far away, because he has worked so much on rule of law. He has written a wonderful small book about it, and he has developed this concept very much. Now here in my quotation, he talks about a secular religion. Let's have a moment of reflection what that means. A secular religion. A religion is something you believe in. It's not only knowledge, but it's something you believe in. So I think it's linked to the idea of trust. It's linked to the idea of accepting something. And so this this is one part of his idea, religion. The other part is universal. So what he argues is that this is a factor that unifies us, whereas there are very many other factors that divide us. And he argues that it is something that we all have in common. Let's have a look at this idea of a secular universal religion. I think it's when we go back in time, we could not say that we had such a secular universal religion all the time. We have a very different heritage when we talk about rule of law. And I think when we look into our constitutional history, nowadays, I guess that all our constitutions have probably in Article 1 or in some central article have a reference to rule of law, but that was not like that some decades ago. So in the Eastern European world, there was no notion of rule of law before the fall of the wall. There was a concept, I say it now in Russian, zakonnost, and that is sort of applying the law. That's a very positivist notion of applying what is written in the law, and rule of law for sure goes beyond this Zakonnost. That is something different. And that is also what I would call a positivist heritage, just applying the law, and as a sort of a misunderstanding, applying the law for rule of law. So after 1990, I think indeed it was taken up as a new concept in Europe as a whole, and it could go back to roots that we could find in different parts of Europe. I think there are basically two different concepts where we also have two different words, and when we translate them, they are not exactly the same. We have on the one hand this rule of law conception, which comes from the British tradition, and on the other hand, we have what we call in my German language Rechtsstaat, where you have the idea of the state involved, whereas there is no idea of state in the rule of law idea coming from Britain. So we have different traditions, they are filled with different concepts. And let me just mention an anecdote that when we talk in Germany about rule of law, it's funny, it's always mentioned, although as far as I know, it's not true. It's the anecdote or this little story about the miller. And it's about the dispute of the miller and Friedrich II, the Prussian king. The story goes like that there was the castle of Friedrich II, and there was a mill nearby, and the mill made a lot of noise. And the king felt disturbed by this mill. So he said to the miller that he wanted to buy the mill, so that he could stop it from moving and from making noise. And the miller said, "No, I won't sell it to you, it's my mill." And then the king would say, but how can you argue like that? Don't you know that I have the power just to tear it down and to take it away from you? And then the miller replied, "Well, you might have this power if they were not the judges in Berlin." So this idea of, it's not true, the story, just to say it's a myth, but it's a myth that we always connect to this idea of Rechtsstaat, that there is right over power. So the king is for the power, but there is some right for the miller, and that goes against it. And I think rule of law concepts, which are quite theoretical, but they also live on the basis of convictions such as the one that we can see in this little story. But we are lawyers, so we have to use rule of law as a workable concept. We have to use it as a tool. And so this concept has been developed, and we do have a lot of jurisprudence on what that concept means. And there I want now to come to the European Convention on Human Rights, where to say it in the first place, rule of law is not in the text of the convention itself, but it's only in the preamble. And that is also the reason why the concept of rule of law was only discovered at a certain point of time, actually in 1975. So we had the early jurisprudence of the court did not mention rule of law. Why was it discovered? In what context was it discovered? It was discovered in the famous Golder case, Golder versus the United Kingdom. It was a case about access to court. Golder was a convicted prisoner, and he was accused of having taken part in a riot, in a prison riot, and he was he argued that he was not a member of those who were involved in the riot, and he wanted to bring an action against the prison guard who had wrongfully accused him of being part of this riot. But he could not accuse this prison guard because he didn't have access to court, because he had no lawyer. And so the question was, in how far there was a human right of access to court. When you look in the convention, you don't have it written in the text. There is no access to courts, but there is fair trial. So in order to have a fair trial, you need to come to the courts. So otherwise you cannot have a fair trial. So it's a question of logics. For the judges at that time, it was like a lacuna that was there that had to be filled. And they decided to fill it with this concept of rule of law. And so let me quote what they said. It may also be accepted that the preamble does not include the rule of law in the object and purpose of the convention, but points to it as being one of the features of the common spiritual heritage of the member states of the Council of Europe. The court, however, considers that it would be a mistake to see in this reference a merely more or less rhetorical reference devoid of relevance for those interpreting the convention. One reason why the signatory governments decided to take the first steps for the collective enforcement of certain of the rights stated in the Universal Declaration was their profound belief in the rule of law. So what the judges did, they used this concept that was in the preamble to interpret the convention. And then they used it for this concept of fair trial, and argued that the idea of fair trial has to be interpreted in the light of rule of law. And what they said, I quote once more, in civil matters, one can scarcely conceive of the rule of law without there being a possibility of having access to courts. So this was how the concept was discovered, as I say, by actually the British judge argued that it was exaggerated, but it was there and he was the only one contradicting. And from this cautious approach of using rule of law for filling lacuna, we arrive later on at a very bold statement of the court. And now I quote once again, now the court argues the rule of law is a concept inherent in all the articles of the convention. So from a small starting point, taking it from the preamble, it was now interpreted as a red thread that goes through the whole convention. Let me just mention several points. So we all know that many of the cases are in the end divided on the basis of the principle of proportionality. So this necessary in a democratic society is interpreted in the light of the principle of rule of law and the principle of proportionality. Or in most of the articles, we find that the restrictions have to be based on law. So this based on law is filled with the idea of legal security, foreseeability, and accessibility, and that these are also basic ingredients of rule of law. Then we have a rich jurisprudence, and Adam Bodnar has already mentioned some judgments about independence of judges, which is enshrined in Article 6. And then Article 6, we find a lot of ingredients of fair trial, like in relation to trials in absentia, condemnations on the basis of the testimony of an absent witness, the presence of a lawyer from the beginning of the procedure, the meaning of the presumption of innocence. So all these concepts are concepts that are sort of vice versa. They fill what is meant by rule of law, and they are filled by rule of law. And then the idea of access to court that was developed in Gold is developed not only from the beginning that you can come to the court, but in the end as well, you have to achieve a judgment that is implemented. So the implementation is taken as a part of the fair trial procedure, and that is also a part of the idea of rule of law. So that is how the court has filled it from a small starting point, coming to a red thread through the whole convention. And what it has developed is more or less the same as what Lord Bingham has mentioned as the 8 ingredients of rule of law, and what the Venice Commission has developed in the famous rule of law checklist. So I think what we can say, and that is sort of the summary of the first part of my lecture, that we do have a differentiated approach developed by the European Court of Human Rights on rule of law. And we cannot say this concept is evasive and vague. It is a concept, it's a tool, it's something that with what we can work. Now let me come to the second part after this explanation of the concept in the European Convention on Human Rights. I want to speak about controversies about the real meaning of rule of law. It's always, actually, it's like religion. There we are back to secular religion. In religion, you can also say, I'm a Christian, but different Christians might have different beliefs, or different Muslims might have different beliefs. So to have a religion in common does not necessarily mean that you really have exactly the same belief. And that is also what is happening with the rule of law concept. You can have it as a heading, but you can fill it with different ideas. And there, nowadays, we watch a lot of controversies in concrete cases. It reminds me a little bit like when you think of colors, we usually agree this is green and this is blue, but then we might have a color that is in between green and blue, where we are not sure, is it already green or is it still blue? So that is the same with the rule of law concept that we do have parts when we apply it where we do not know, is it on this side or is it on the other side? And I want to explain two examples where I want to show you that nowadays we do have questions what it means, what is exactly the content. And I want to show it to you with two examples. One concerned, and two examples taken from the jurisprudence. One concerns the concept of arbitrariness, and the other one concerns the concept of independence of the judiciary. So the concept of arbitrariness might be seen just at the opposite of rule of law. If you say it's difficult to define what is rule of law, you can always help yourself and say, well, it's the opposite of arbitrariness. But to look at how the concept of arbitrariness is used, I think we find different approaches. We have in the European Court of Human Rights used the concept of arbitrariness basically when it decides on fourth instance. Usually the court would say that it never decides cases in the fourth instance, it's not its job, but under Article 6, but if a national judicial decision is considered to be arbitrary, the court would take it up. And in this context, the court has developed a concept of arbitrariness. And I just quote now from the case Kamidov versus Russia. There it says, in the court's view, the unreasonableness of this conclusion is so striking and palpable on the face of it that the decisions of the domestic courts in the 2002 proceedings can be regarded as grossly arbitrary. So this is a case, a Russian case, where the evidence was absolutely clear that the house was taken by the police from a Chechen family. The evidence was absolutely clear, the papers, everything showed it, and still the court said that they had not occupied it. And so the court used it to have this formula, unreasonableness of the conclusion, striking and palpable on the face. This is, if we analyze now, what are the elements taken to find a decision arbitrary, I would say first thing is that there is a basic problem with the logic. So it's not applying the basic principles of logic if you see that you have evidence for something and you say you don't have evidence for this fact. The second, in my view, as it said, striking and palpable, it must be obvious. It's something that is really visible. And I wonder, and that's perhaps also a question I want to ask, if this obvious includes also the idea, this understanding of arbitrariness is shared by all. It's not only some seeing it as arbitrary, but it must be something that is visible for all. And the last question I have, when I look at this concept of arbitrariness, does it imply some sort of bad will? to interpret, as in this Russian case, to interpret just in the exactly opposite to what you see in reality. Just to give you another example, Bochan versus Ukraine is a case that went to the Grand Chamber. And there was a judgment of the European Court, which found in a case about a title of land that the judges were not independent and not impartial, and there was no fair trial, but there was no problem of length of procedure. And the Ukrainian judges, when the case was taken up on the national ground once again, they just turned it around and said, no, there was no problem. The court has said there was no problem with independence and impartiality, but there was a problem with length of procedure. So it was just turned exactly the opposite of what was written. And there as well, the court said, well, something like that is arbitrary. My question is now, is this a universal concept? Do we always have the same approach to what means arbitrary? And with this question, I will turn to a judgment of the Federal Constitutional Court that I see very critically. That is the PSPP judgment of May 2020, where the Federal Constitutional Court held that the judgment of the European Court of Justice is ultra vires, and therefore it's not accepted as a valid judgment by the Federal Constitutional Court. And this, the reasoning of the Federal Constitutional Court in this context is also based on arbitrariness. It argues that the judgment of the Luxembourg Court is arbitrary. So what do we find here as an idea of arbitrary? I just quote the central sentence. In its judgment of 11 December 2018, the Luxembourg Court held that the decision of the European Central Bank Governing Council on the PSPP and its subsequent amendments were still within the ambit of the ECB's competences. This view, now it comes, this view manifestly fails to give consideration to the importance and scope of the principle of proportionality, which applies to the division of competences and is no longer tenable from a methodological perspective, given that it completely disregards the actual effects of the PSPP. So that's their argument why it's arbitrary. So basically 2 points. The first, the non-recognition of the importance and scope of the principle of proportionality. So this is meant as arbitrary, and second, the disregards of the actual effects of the measure. So if we come back to what the European Court of Human Rights argues or understands as arbitrary, basic elements of logic, are there basic elements of logic missing in the Luxembourg Court's judgment? I don't think so. It's a different concept of proportionality, but it's not the missing of basic concepts of logic. And is it obvious? Obviously, it was not obvious because nobody had held it to be arbitrary before. And the Federal Constitutional Court needed almost 40 or 50 paragraphs to explain why it was arbitrary. So it was not obvious, and it was obviously not shared by all. And I don't think that there was bad will in it. So the problem is, and that is what I want to show, that even such a concept like arbitrariness can be understood in 2 different ways. The second concept where I want to show different visions is independence of the judiciary. And there I want to take up on the one hand the case already mentioned by Adam Bodnar, Alexander Volkov versus Ukraine, and on the other hand, Ramos Nunes de Carvalho versus Portugal. I guess you might know the Volkov case. It was a dismissal of the president of the military chamber of the Supreme Court of Ukraine. He was charged with what they called gross procedural violations, and he was dismissed because of breach of oath and the judicial control of the higher administrative court was restricted. The court in this context found numerous violations of the independence of the judiciary. I'm not going to argue now about the judgment in general, but I want to take up one point, and that is the independence of the higher administrative court which was on the one hand the disciplinary, which was the higher court of administrative court was under the disciplinary review of the Judicial Council. And this was the question in how far the judges who had to decide on a decision given by the Judicial Council were independent when they were themselves prone to be assessed by this Judicial Council. And there, in this construction, so to say, that the Judicial Council had the disciplinary power of the judge over the judges of the higher administrative court, the Strasbourg court decided that there was a lack of independence. Let me just quote the Volkov judgment, what is said here. The court observes that the judicial review was performed by judges of the higher administrative court who were also under the disciplinary jurisdiction of the higher Judicial Council. This means that these judges could also be subjected to disciplinary proceedings before the higher Judicial Council. Having regard to the extensive powers of the higher Judicial Council with respect to the careers of judges, appointment, disciplining, and dismissal, and the lack of safeguards for the higher Judicial Council's independence and impartiality, the court is not persuaded that the judges of the higher administrative court, considering the applicant's case, to which the higher Judicial Council was a party, were able to demonstrate the independence and impartiality required by Article 6 of the Convention. So this idea of being under the disciplinary overview of the Judicial Council was taken as a factor for lack of independence, together with this idea that there has to be not only justice to be done, but seen to be done, and the question of appearances. And it was said this is an appearance that makes the court decide that the Ukrainian higher administrative court is not independent. The problem was, however, if what was said in Volkov was applied only to a very specific situation, or it could be extrapolated as a general rule and transferred to other legal systems. And there, while the judges, the Strasbourg court judges, were unanimous in the Volkov judgment, it was a chamber judgment 7-0, in the Grand Chamber, when the same problem came up, there was no more unanimity of the Strasbourg judges. In the case Ramos Nunes versus Portugal, the court was once again confronted with the assessment of a similar problem to the one the court had to assess in Volkov, a disciplinary procedure against a judge, this time not leading to the dismissal, but to a disciplinary sanction. It was the suspension of office for a certain period of time. And once again, one of the problems was the question of appearances. The Portuguese Supreme Court had to decide in the last instance, and the Judicial Council, an organ similar to the Judicial Council in Ukraine, was in some way on both sides of the decision on the disciplinary measure. On the one hand, it was responsible for the disciplinary measure. On the other hand, it was behind, in inverted comma, the Supreme Court, as it had the role to play regarding the careers of the Supreme Court judges and potential disciplinary procedures against them. And now, unlike in the Ukrainian context, the Strasbourg court considered the risk, I quote, purely abstract. It explained that the finding in the Volkov case could not be transferred to other cases without taking into account the specific circumstances. And now a quote from the Ramos Nunes judgment: these findings should be regarded as a criticism, so these findings in Volkov, should be regarded as a criticism based on the circumstances of the case and applicable in a system with serious structural deficiencies or an appearance of bias within the disciplinary body for the judiciary, as was the case in the specific context of the Ukraine system at the time, rather than a general conclusion. So it was specific and not general. and then it talked about a purely abstract risk of this kind cannot be regarded as apt to cast doubt on the impartiality of a judge in the absence of specific circumstances pertaining to his or her individual situation. So it came to a different conclusion. It didn't find that the court was, there was a lack of independence in this case. And out of the 17 judges, 6 dissented, and they argued that the same principle should have been applied in the Portuguese case as well. So you see my two examples, arbitrariness, independence of the judiciary, and we see that there are different conclusions drawn from these concepts that are all covered by rule of law. So I come to the third part of my intervention and want just to ask, is there then a sort of rule of law relativism? Can we say that it's only a relative concept and it's not the same for all? I think no. To be clear, I think it's not a relative concept. It is true that there are debates about the concept, but still there is a core of the concept, and there are debates about how to use it in specific circumstances, and that's what notions of law are always about, that there has to be a debate about it, but it's not a relative concept, and there is a clear core idea, and there I want to go back to what the court says about arbitrariness. The core is at least that when there is a break, and that is obvious, and that is visible for all reasonable people, and especially if there is bad will behind, it's a breach of rule of law. In this context, we can go back to the checklist, rule of law checklist established by the Venice Commission, which I find extremely helpful and which shows, and now going back to this notion of secular religion, which shows sort of the orthodoxy, which shows what is really in the core concept, like the legality, supremacy of the law, compliance with the law. All these issues, I'm not going to enumerate all of them, that are listed by the Venice Commission, they are within the core and they cannot be relative, they have to be the same in all different countries. Nevertheless, there is, and that is visible in my cases, especially in the Portuguese versus the Ukrainian case, rule of law, there is a factor that is important to see, and that is legal culture. So the same regulation can have very different consequences in one country and in the other. The most famous is probably the Switzerland. In Switzerland, the system about electing judges and judges being proposed by political parties, something that is shocking from outside, but within the legal context and the legal culture of Switzerland, it had the effect that still 80% of the population have trust in the judiciary. But we do have to see this question of legal culture that comes in, and that we cannot understand rule of law always at looking only at a regulation in the abstract, but we have to look at it in the context. And when looking at it, I want to give now, just for the end, 2 examples where there cannot be any doubt about problems with the rule of law. And there I want to rely on opinions given by the Venice Commission. One concerns the new constitution of the Russian Federation. And we have an opinion of the Venice Commission on this, on the new regulation that concerns also judges, just in 2021. In the new constitution, we have an amendment that the president has the power to propose to the Federation Council the termination of the president of the Constitutional Court, the vice president, and all the other judges. And and the president can propose the dismissal of all those judges, and the clause is when they commit a violation tarnishing the honor and dignity of a judge. And this is criticized by the Venice Commission as a completely vague concept where you can take anything inside this concept, and it seems to have a chilling effect on the independence of the judiciary, and as long as it's not filled with some element like bad will or with intent or with gross negligence, it's an instrument for what the Venice Commission calls a serious danger for the rule of law in the Russian Federation. So this is just to have an example where there is no relativity, where it's clear. And the other example is also an opinion of the Venice Commission concerning Poland. I want to quote this or to take up this opinion of the Venice Commission out of 2017 about the extraordinary review of final judgments, where the Venice Commission compares the new system to the Soviet model and argues in the same way as with the Russian constitution that allowing the review of judgment that have already entered into force for social justice is completely vague and creates a huge problem of foreseeability, also concerning the revision of facts that is possible even without the knowledge and consent of the parties. And in the end, the Venice Commission argues that the reversal of old judgment that are already final and are not subject to any review anymore generally, and not only under very specific conditions, is what it says literally worse than the Soviet system, and it jeopardizes the stability of the Polish legal system. So these are examples where we see that the concept of rule of law leads to very clear results and is not relative. Conclusion now, is rule of law a secular religion? Let me just make 5 points. I think the first, the fact that nowadays all states have enshrined the principle of rule of law in their constitution is a sign of progress, as it shows that rule of law is accepted as a universal value. Second, subtext is, however, very important. It's important to see how this abstract concept is used in practice. And so my third point is that there can be difficult debates on the contents, especially in view of the soft factor of legal culture. But fourth point, rule of law is constitutive of the European idea. The whole European idea is built on treaties and thus on law. And thus, and therefore my fifth and last point, that there are core elements of rule of law, and with those core elements, there is no relativity. And how we can find them out, I want to rely on the Vienna Convention on the Law of Treaties, which gives us an orientation about interpreting, and I think it makes it clear how we have to interpret rule of law. Let me quote: "It shall be interpreted in good faith, in accordance with the ordinary meaning to be given to the terms, in the context and in the light of its object and purpose." Thank you very much for listening to me.
Thank you very much, Professor Nussberger, Judge Nussberger, for this elaboration of the concept of the rule of law that you named as a kind of a secular religion, which is, I think, very inspiring, like thinking this way and also indicating those elements of this, let's say, religion. And I think it really complements highly to what was presented last time by Professor Martin Krygier, who is today with us. So I can imagine that he would like to maybe later on comment on this a little bit, just to make this exchange with our previous session. I know that we have a lot of wonderful guests today with us, a lot of scholars, a lot of practitioners, judges, from all different countries of the world. But let me allow just to say that there is one very special to me person who helped me a lot during my term as the ombudsman of the Kingdom of Netherlands, Mr. Reinier van Zutphen. So Reinier, it's great that you are here with us. Ladies and gentlemen, I would like right now to ask Dr. Barbara Grabowska-Moros to take a floor. Just let me say a few words about Dr. Grabowska. She's currently research fellow at Central European University Democracy Institute in Budapest, Hungary. She's working together with Professor Dmitry Kochenov. Before, she was working at the University of Groningen. In the Netherlands, she was affiliated with the Helsinki Foundation for Human Rights, quite strongly involved into the litigation of presidential cases, also before the European Court of Human Rights. She is a graduate of the Warsaw University of CEU, and in 2017 she defended her doctoral thesis on the democratic oversight of the special security services in Poland. So Barbara, Dr. Grabowska, the floor is yours.
Thank you. I think there were so many thoughts and ideas presented by Justice Nussberger, and I think covering all of them would be impossible within 15 minutes. According to my notes, I will concentrate on 4 of them. We'll see if time allows me to any further questions. I think I had exactly the same feeling as Adam did in the very beginning, that this today webinar, the today keynote speech, was in a very direct link with the previous one given by Professor Martin Krieger, meaning that the rule of law is actually not about the beautiful checklists, however useful they can be for practitioners, but it is actually about the purpose of the rule of law, meaning fighting with arbitrariness of public power, of public authorities. And even today, I used one of Professor Krieger's writings when he said that the attainment, the successful attainment of the rule of law is a social outcome and not a merely legal one. So from the perspective of thinking about how the rule of law needs to be implemented in practice, this is actually a huge challenge also for a lawyer, which means basically how to express the rule of law in the law in order that it will meet the requirements of the legal precision. How can you rule about the rule of law to be sure that it will not just be given very vague ideas? I mean, what was said by Professor Nussberger, those very precise elements, how the rule of law can be seen as a precise and not vague concept, I think we had really interesting examples for that. And just as an example, I was thinking about the arbitrariness. I think somehow we can also compare it with the peer review process when you're submitting articles to academic journals. There is this peer review, which can be seen as a system of checks and balances, just to ensure that the quality of the article, the quality of the academic journal will be really high. So when you think about democracy and the state and the law adopted by the state, you can think that this rule of law concept is actually about securing that the quality of law in a way that it is applied to people, that it will be actually of a good quality, and that it will not affect negatively human rights and fundamental rights and justice. My second point was actually about the justice and its role between this different elements, between democracy, between the rule of law, between fundamental rights, and there is, I think there is still a space for justice. When I think about or trying to find this place for explain what would be the place of justice, the main piece that comes to my mind, which we discuss in details, the idea how can we place justice between all those basic values, is the book Europe's Justice Deficit, edited by Dmitry Kochenov, by Gren Burka and Andrew Williams, and the book discusses really all possible aspects about how the justice is somehow just missed in the discussion about the rule of law, about fundamental rights. And I think it's a huge opportunity for the rule of law actually to be connected with the justice, in a sense that it can be brought before the court and can be discussed before the court by the parties. Right now, what we see is actually a huge chance for the rule of law to be really well defined and discussed. And what I mean by that is the so-called the rule of law conditionality mechanism that is going to was challenged already by Poland and Hungary, and it will be discussed in the front of the Court of Justice, which I think gives us a good opportunity to see how the EU can use, on the one hand, on the case law of the European Court on Human Rights, how can it be transferred directly to the Court of Justice, but also how the notion of the rule of law can be defined itself. My third point was actually about looking into places, categories, or definitions that can be somehow I mean, when the justice is actually not served from the perspective of the rule of law. And again, my idea of that comes to or is supported by the idea of just judicial review and this idea presented by John Ely, saying that in a country, you know, even with democratic rules, there can be still a place where someone's rights need to be discussed, but not in a majoritarian process, in the process of voting, but they need to be secured in a kind of counter-majoritarian way, meaning by the experts, by independent experts, meaning before the courts. And when, again, I look at the issue of justice, but from the perspective of the European Union, I think we have huge problems with that. And I think it really affects how we perceive justice and the rule of law in this perspective. Right today and yesterday, I was working on migration crisis issues in Europe. And one of the major problems, I guess, which was noticed and which shows that justice isn't correctly served in Europe is the attempt to judicially challenge so-called EU-Turkey deal adopted by the EU, by EU member states in 2016, if I remember correctly the date. It was the deal between the member state and the Turkey, dealing, basically meaning that the Turkey will try to take care of refugees from Syria, and if any will try to enter Europe, they will be probably returned to Turkey once again. There was huge discussion whether this rule and this deal was legitimate at all, to what extent it protects human rights of asylum seekers from Syria who are trying to reach Europe through Mediterranean area. And what happened, there were a couple of people who tried to challenge this EU-Turkey deal before the Court of Justice. And the Court of Justice said that there is no legal standing because the deal wasn't reached by the EU, but by each EU member states working together, but not by the EU. So it is not a EU law, it is not sources of EU law. That's why it cannot be challenged and reviewed by the Court of Justice. So here, even though the issue was of high importance for the rule of law and for the human rights protection in the European Union, it wasn't heard by the Court of Justice. And I just realized today that also another judicial independence case, meaning the case of Portuguese Association, ASJP, the case actually dealt not only with the judicial independence, but actually with the Eurozone crisis and the consequences of the Eurozone crisis. So actions adopted by the Portuguese government on the basis on agreements adopted by EU institutions, by member states, but not by the EU itself. So again, it was impossible, in fact, to challenge those instruments in front of the Court of Justice. But at the same time, even though in this particular sense, the justice wasn't served, we received a really good judgment on the judicial independence. So I think from this perspective, this case is particularly interesting. And my last point, I think it will deal also with the last point of Justice Musburger's speech, meaning the rule of law relativism. The topic I'm working currently at the CEU Democracy Institute, it deals partially with exactly the same claims. What can we see in Hungary, but also in Poland? There is this idea that rule of law is vague, which means it can be differently defined in different states. And also, it's not a rule of law, it's so-called rule of law, which gives a huge place for interpretation. What can be found in this notion? And one of the tools that helps the heads of the governments to argue that the rule of law is empty, or that the EU institutions who are aimed and tasked with protecting the rule of law, that they're actually applying double standards policy about the rule of law. So what comes to my mind is something which I called abusive comparativism, and it deals with trying to compare different institutions that deal directly with the rule of law and try to compare them with different legal systems. And I think in case of Poland, the major example was the Council of the Judiciary, when the government trying to present the draft adopted finally in 2017, trying to present how the Council of Judiciary look in different places, meaning in Spain, in Germany, when apparently the judges are being elected by the politicians, or in Czech Republic, where you can find no Council of Judiciary at all. So depending on the argument, you can find different methods adopted in such comparative reasoning. Sometimes you can see that, if there is a certain legal institution existing, for instance, in Germany, and it hasn't been challenged by the European Commission, it basically means it meets the EU standards. And what seems to be extremely useful in this particular case, that would be exactly the definition offered by Martin Krygier, meaning looking at such comparative argument from the perspective of arbitrary use of law, and not from the perspective of, very clear-cut ideas such as legality, legal certainty. But on the other hand, also what comes to my mind and what can be really relevant in looking for this abuse of comparative mechanisms is exactly the bad will that Justice Nussberger already mentioned. You can see in those arguments that you're doing exactly the cherry picking and trying to find such institutional solutions that would be good and support your arbitrary change of law. I think I reached my conclusions. However, I have many other thoughts in my mind, but I think we have plenty of time to discuss them during the discussion. So thank you a lot.
Thank you, Dr. Grabowska, for sharing with us your comments and thoughts concerning the speech by Professor Nussberger. I've just realized that the next speaker, and that there is like one factor that connects me and two speakers today. That's quite interesting, that three of us, I mean me, Barbara, and Kristaps Stamus, all of us have the degree Master of Laws in Comparative Constitutional Law from the Central European University. That was not planned, that's quite interesting that we have a little bit like a similar background. But let me just start by introducing Kristaps Stamus, who is the head of the legal department of the Constitutional Court of the Republic of Latvia. He is working also and cooperating with the Riga Graduate School of Law. He was working for more than 6 years at the European Court of Human Rights in the registry as an assistant lawyer, but also as a lawyer, and he was responsible for processing applications coming from Latvia. And he has also a lot of other international and scholar experience. So Kristaps, the floor is yours.
Thank you very much, Mr. Bodnar. And thank you very much, Judge Nussberger, for your presentation. That and what I read from your published papers together was sort of eye-opening in terms of giving a certain critical approach to rule of law, not only praising one that seems to be coming from certain areas. But what interested me the most was the link between the rule of law and justice, and your thinking about whether rule of law always goes hand in hand with justice, and whether rule of law sometimes cannot be opposed to human rights. And when thinking about that, one case that came into my mind was something that was reported widely in media, a case about coming from Italy, a criminal case where person was initially convicted for stealing a piece of bread from supermarket, and eventually this person was acquitted because the Italian courts ruled that he had acted in extreme situations. He would not have had anything to eat. He would have starved to death unless he stole that piece of bread. So he was completely acquitted from in the particular criminal case. Now, the outcome of that case will certainly be seen as just. So it serves justice almost in the eyes of anyone in the world, except maybe the owner of the store where he stole the bread. But the question of rule of law in this perspective is much more interesting and much more questionable in a way. If you look at the rule of law in terms of законность, as you mentioned, the Russian term, which can roughly be translated into legality, then this is certainly, the decision of Italian courts is certainly not in line with rule of law, because this certainly goes against criminal law. So they misapplied criminal law and they did not apply it correctly. And therefore, this would be an impermissible judgment. But this view is clearly wrong, and it is wrong because it comes from a misunderstanding of what the law is. So if you speak in terms of a legality, legality can mean the same thing as rule of law, but only if you understand law in a non-positivist sense, if you understand law as a broader concept, law that also includes other extra, other considerations that come outside from a purely written text of the law. And if you understand law in this sense, then there is no difference between the concept of законность or legality or rule of law. Because if you understand the concept of law properly, then this will always lead to the correct result. And this law, in this sense of the word, will always include justice. So the application of this law as correctly understood will always lead to just results. And therefore, there will be no conflict between rule of law and justice, because the rule of law will always lead to justice. But now this depends on how you understand law, and this in turn depends on who is the one who says what law is. And there we come to the potential relativity. And another thing that I really appreciated in your presentation, and which was also touched upon by Dr. Grabowska-Moroz, was the relativity of the three concepts. First, rule of law, second, justice, and third, arbitrariness. And I think we could put them on a sliding scale, where the rule of law concept is actually the least relative of them all, because of the existence of the checklist, because of the existence of works of Lord Bingham, and also because of the existence of a certain consensus among civilized nations, as they're called in the Statute of International Court of Justice. So you do have a sort of clear understanding of a core of rule of law, which is shared by pretty much anyone. On the other hand, justice and arbitrariness are not concepts that are clearly shared by anyone. And in this way, they move in the direction from a secular religion to a non-secular religion. So a religion in a proper sense of the word, because you have to believe that something is just. You have to believe that something is non-arbitrary. And yes, the concepts of justice and non-arbitrariness will be instinctively shared by many people who apply these concepts. But there is no clear benchmark against which you can test whether something is just or non-arbitrary. Therefore, this is something that you need to believe in. And this belief and this understanding, which actually would need to be shared, is one of the problem areas that I see in our region, in Latvia and Poland, in the whole Central and Eastern Europe, because the transition from understanding law as what is written on a paper towards law that includes the concepts of non-arbitrariness and justice is a difficult one, and it has taken a lot of time, and the transformation is still going on. And here I would like to turn to the role of the European Court of Human Rights in this respect, because the European Court of Human Rights has served this transition in 3 different ways, and I will explain that from the perspective of interaction between Strasbourg and Latvia to a certain extent. So the first stage of interaction between Latvia and the Council of Europe or the European Convention was one of awe. Everybody was excited about this new brilliant ideas coming from the European Convention. And when the human rights chapter of the Latvian Constitution was drafted in '97, then everybody was just taking the ideas from the convention and throwing them on the table and being very excited about it. And there was also a lot of misunderstanding about what the convention says and what are the standards of the convention. So for instance, when Article 116 of the Latvian Constitution was drafted, so that is an article that permits restrictions to human rights, the drafters had proposed to include a formulation that restrictions are only permissible if they're necessary in a democratic society. And one of the members of the parliament stood up and said, "This is absurd. How can it happen that restrictions of human rights could ever be necessary in a democratic society? Let's strike that line out." So that line was taken out of Article 116, and restrictions of human rights were permissible if they were provided by law and had a legitimate aim. And it took the Constitutional Court a few years to take the proportionality element from the practice of the European Court of Human Rights and to put it back into the Constitution, where it's still absent, by the way, from the written text. So the first was this transfer, this is awesome, we'll take it, we need it for Latvia as well. And then we move on to the second stage of a respectful dialogue between the European Court and the national courts. And here, an example from the practice of the Latvian Constitutional Court, and this is a series of cases that pertain to state secrets, access to state secrets, and the state secrets were discussed first by Latvian Constitutional Court in 2003. Then the European Court responded in 2014, Latvian Constitutional Court responded again in 2017, and the European Court is now to give its final word in 2020. So this is the respectful dialogue part where we shape each other's sense of justice. And the third stage, which is an unfortunate one, which Professor Nussberger in her writing is calling bad faith criticism, is when the national courts think that they're more smarter than the European Court and they impose their own understanding of rule of law, justice, and arbitrariness, and this leads to results that are not desirable, and this leads to the perceived conflicts between these institutions. As Dr. Grabowski, I also have a lot of other thoughts running through my head, but I think I'm running out of time, so I'll now cede floor to some discussion with the participants.
Thank you, Kristaps, for your comment, for your intervention. And now I would like to give the floor to Professor Angelika Nussberger for just a short comment to those 2 interventions. But if you could please keep it a little bit keep it short, because we should have time for the discussion with all the participants, and I imagine there are a number of questions and interventions, and I have even some questions that have been sent to me by some friends before that couldn't participate in today's seminar, and they would like via me ask those questions to you. So please, Professor Nussberger, floor is yours now.
Yeah, thank you very much for your comments and just a very short feedback. I want thank you, Dr. Grabowska. I find very interesting or almost funny your idea about the peer review. So to because the element that is, it's a double. Two elements, it's peer and it's review. So I think that is probably an interesting approach. Peer means that you have people understanding what it's all about. So it's not a review by somebody who does not know what it's about, but by somebody who is an expert in the field. And that brings me back to my concept of arbitrariness or also rule of law. Is it something where we have to have an expert understanding only, or has it to be common? And there I can also make already a reference to Kristaps, because that's this idea of justice, or what you said, you have to believe in it. It's a question, is it really a peer review, or is it an everybody's review? So something that has to be understood and felt by everybody. So this was one aspect that I wanted to take up. And the other one is the idea about abusive comparativism. I think that is true. We are all sort of, to a certain extent, comparativists. We are interested in how legal concepts can be used in different contexts in other countries. It's interesting to see how ideas migrate from one system to the other. But indeed, we have something, and I think that is something that we see only now, abusive constitutionalism or comparativism, where we use concepts with bad will and turn them around and make them dysfunctional. And that is extremely dangerous when we take generally accepted concepts like rule of law or like democracy, and then under this heading, we turn them around and make something very different out of it. I have always observed this, abusive idea with constitutional courts being used as power instruments for those in power. So famous example, when Yanukovych was unhappy with a changed Ukrainian constitution, and then the Ukrainian Constitutional Court decided that this unfavorable constitution was null and void and went back to the former constitution. So the Constitutional Court, which is a very esteemed institution, is used in an abusive way in order to enlarge the power of those in power. So it's just the opposite of the idea of a Constitutional Court. And that is something that we see more and more with this migration of ideas, and we have to be very well aware that what we say, it's not always gold that glitters. We always have to have a very close look to what is meant. And now coming to Kristaps, I liked very much your sliding line, or what you said about rule of law, sort of the least vague, I think that's what you said, and then arbitrariness and justice is then something where you said we have to believe in, and you came back to my idea of the religion. I must admit I still have to think about it, if it's really something. I agree, justice is the most abstract notion. There I completely agree, but I'm not yet sure if arbitrariness and rule of law are on a different scale in this context, or more or less on the same. They are filled with contents quite a lot, but still, as I try to show in my speech, there are open questions that remain. And the example you gave about legalism and rule of law, that is an extremely interesting example that was also used in French doctrine. You know that in France, there's a very solid reluctance for judges to develop the law. And they had this example, and that was discussed over decades, if a judge acting in such a way against the law is acting in the right way, if this is the power of the judge, or if the legislator should make another law allowing for those stealing and hungry, that this is not counted to be a theft. So it's not only a question of justice, but it's also a question of who is the one to define justice in the concrete case. Yeah, perhaps I stay with these 2 points for each of my commentators, and I thank you very much for your comments.
Thank you very much, Professor Nussberger, for your comment to interventions. Ladies and gentlemen, I think right now we have more or less like 35-40 minutes for the discussion. So I hope that all the participants are already ready with their questions or comments prepared. If you would like to take a floor, could you please write to me or raise your hand, like this virtual hand, which is basically available in the Zoom, and I will collect a couple of them. Then I will ask Professor Nussberger to answer, or maybe also our commentators to answer if they would like to, and then we'll go to the second round. And I see that Professor Martin Krygier is raising his virtual hand. So we really truly appreciate, Professor Krygier, that you are with us, because it seems to me that it is a very, very early morning in Australia right now. Is it true?
It's late night.
It's late night. Okay.
Late night. So I haven't been asleep, but I'm about to go to sleep. But thank you, Judge Nussberger. It was a fascinating talk, and I wanted to ask you about the interaction of your account of rule of law and arbitrariness. On the one hand, it seemed to me that your account, partly drawn from the Venice Commission, of rule of law was of what conditions needed to exist for the order to be called a rule of law order. The rules need to be clear, they needed to be prospective, judges independent, and so on. So they don't say anything about the result. They talk about conditions which are congenial or not congenial to a good result. But when you spoke about arbitrariness, you gave substantive criteria, no logic, obvious, bad will. And I wanted to put these together or to take them in reverse. If you're looking, and this is really a question for edification, for instruction, it's not a critical question. When you are a judge in a court like the one you're in, or in other courts, if somebody asks, is a decision arbitrary, then your three criteria are among the criteria that one would look at. And they focus on the legal judgment that has existed. But if you ask, what are the conditions which would ensure or at least protect the possibility of the rule of law, it seems to me that the nature of the formal law is only part of the story. And so when Barbara talked about she talked about abusive comparativism, and you mentioned abusive constitutionalism. Many of those formal conditions stipulated by jurists, analytic jurists and courts are fulfilled. One of your former colleagues, Professor Andras Scheil, worries a lot about the extent to which what he calls populist governments cheat people in accordance, he says, with the rule of law, because the law is kosher. The law is prospective, it's clear, it does all the things that laws should do, but it's a cheat, it's an abuse. And I'd be interested to know, how do you approach these abuses when the real story is not in the formal characteristics of the law, but in the way these once apparently clear distinctions between clear law, unclear law, prospective, retrospective, are simply shams, because the real activity, the real abuse, is behind the scenes. It's not in the forms of law. It's in politics. It's in social relations. It's in who is appointed rather than how they're appointed, and so on.
Wonderful. That was the first set of questions, I would even say. Now I would like to explain why I was so basically confused with these time zones, because I received one question from our great friend, also from Australia, Professor Wojciech Sadurski, but who is actually right now in New York. So that's why I thought it is the morning. It is more or less like 5 o'clock in New York. But Professor Sadurski sent me a question to you. So he wanted to pass best greetings. So his question is like this: do you think that the experience with pilot judgments so far gives basis to an optimistic prediction that it may become a central device in constitutional justice in Europe by turning the Strasbourg Court into a sort of constitutional court for Europe? Perhaps significantly a large proportion of pilot judgments were handed down in cases arising out of Central European countries, or rather that these were merely episodic exercises of traditional judicial power of ECHR, a Strasbourg equivalent of a sort of class action. Both these different interpretations were provided in the literature. What is your opinion? And once with best regards to Professor Nussberger from Wojciech Sadurski. Okay, I think these are quite two complex questions. And maybe I will add just the third one. So there is a question by Mr. Jan Gauka from SWPS University. Mr. Gauka writes like this: I have a question. Is really the rule of law anti-positivistic institution? I disagree, because positivistic point of view on law is not just understanding law as what is written in statutes. Maybe our speakers would like to share their perspective on that problem. So just 3 questions, and maybe just, we would like to listen to your answers, and then we'll come back to the second set of questions. So Professor Nussberger, floor is yours.
What a challenge. Not only coming from New York and from Australia at the same time, but such deep and difficult questions. Let me start with the last one about positivism. I think it depends, as so often, about the notion of positivism. You can use positivism as what has developed in the end of the 19th century as a method of interpretation. And that is something different from the way I used it as a sort of a negative statement of clinging to the text only and using it whatever is written. So to give one of these, for me, striking negative examples, when you have in Russia the judges reading out page by page these judgments, and then one page is missing, and then because it's not printed out, and then they say, no, we cannot pronounce the judgment, we have to read it out again, hours and hours. So this is positivism, or I don't know if this is a good example, but this is this negative, I would say this negative aspect of being positivist, of applying just the letter without the spirit of the law. This is what I understand in the negative way, but this is not when you think about a legal doctrine developed in the 19th century, positivism, that is much more differentiated and a different approach. So I used it as a sort of a synonym for applying the law without applying the spirit of the law. That was the meaning I wanted to use it. Concerning Professor Sadurski's question about pilot judgment and in how far the European Court of Human Rights is a constitutional court, we have this procedure used in quite specific cases. For me, the idea of the European Court of Human Rights as a constitutional court is not especially linked to pilot judgments. Pilot judgments are, for me, more a technique. It's a technical approach to solve questions which are very widespread and where in the end there is a ping pong. So the court decides, give the general concepts back to the country, and then they are applied. I remember the Slovenian cases about the how were they called, these people that were effaced, whether the identity was effaced, and we had 20,000 of such cases, and then the Strasbourg court decided how to deal with it. It was given back to the national system. So this is, for me, in the first place, a special technique, and that is used in specific cases. I would argue that the sort of constitutional nature of the European Court comes in perhaps in this respect as well, but mainly in the fact of developing common concepts for the whole of Europe. There, where it develops new concepts because no answers have been given so far, there it acts for me as a constitutional court where these ideas are taken up as erga omnes, even if judgments concern like France and then Germany take them up in an erga omnes spirit. That is where this constitutional court aspect comes in for me more visibly. But yes, pilot judgments are an element, but they are so often they are like prison conditions, or so they are questions that are very basic, and the Constitutional Court is famous not only for deciding basic cases, but for giving directions. And so for the role of a Constitutional Court, I would just add other elements to make it a full picture, to give it a full picture. And now this very difficult question of Professor Krieger about on the one hand, this the Venice Commission approach, as you said, defining the conditions for arriving at a rule of law inspired outcome. So you talk about the conditions, and you say, well, you can use these conditions, and then in a way that you come to the wrong result nevertheless. So it remains a street you go, but you arrive at the wrong result, and then it doesn't really help you. So when were talking, I was wondering if you could perhaps differentiate between input conception and output conception. So what you see with the Venice Commission is an input conception. You say you take a clear law, a foreseeable law, legal certainty, you have a judge that is independent, you have that as an input, and then in the end you expect, or that the conception, when you have all these elements working well, you will have a fine output. And there you say, but perhaps there is some misuse because the judge, but I'm not so sure if you can, and that is why I think this conception of the Venice Commission is not only an input conception, because if you said, but there can be political factors coming in, why, but these political factors are captured by this conception of the conditions set by the Venice Commission. For example, when you have independence of the judiciary, you always have this necessity to look behind the scene and to look at appearances. So when you talk about political influences, the conception of independence of the judiciary is conceived in such a way to catch that as well. So if you apply these concepts in the right way, I would expect the outcome to be okay as well. But I think the concept of arbitrariness is an outcome-oriented concept, and especially as I have defined it, I look at the result, and I say, what has happened here, it's not understandable, it's against the understanding of the logic, what has happened here, so I look at the result, and then I arrive at the criticism that something is arbitrary. So that is one possibility of talking about input and output. The other one, and that was actually, before you spoke, the one I had probably more in my mind, was to say it's like the opposite. And rule of law is here, and arbitrariness is the opposite of rule of law. And it's the basic So the basic basis. So there's more in rule of law, but arbitrary, not arbitrary, that is the least you have to guarantee. So in this sense, the relation between the two notions would be as a degree. So something that is not arbitrary is not necessarily really living up to rule of law. It can still have problems with rule of law, but at least it's not arbitrary. It's the lowest standard. So I would try to develop two approaches: one an input-output approach, and the other one a lower level and a little bit a higher level.
Good, thank you very much. Barbara, Kristaps, would you like to add something, some short answers to maybe those questions or issues, or should we go forward with next questions?
One sentence when it comes to question about positivism, if it's still on the table. I mean, the strong link deals with the requirement that the public decisions are made on the basis of law. So I think this is a strong link with the positivism. And the last year experience in Poland dealing with organizing presidential elections show how rule of law backsliding affects directly the democratic process in country where decisions about organizing and non-organizing elections were taken without any basis in the law. And just one small remark, it also deals with the current events in Poland. 2 weeks ago or 3 weeks ago, when there was this shameful hearing before the Polish Constitutional Tribunal dealing with the status of the Ombudsman office, my colleague, he's a lawyer, he asked me if I'm going to watch the hearing, and I saw it's almost impossible. My 1-year-old makes it impossible to hear any hearing. And I said, but the outcome of this hearing will not be theoretically relevant. Meaning, yes, there will be a decision, but I don't think it will matter because the whole body is not independent at all. And what he said, but it's legal positivism. We don't have any institution that will verify the status and independence of this body. And as a kind of an update, it appears that on the 8th of May, there will be a decision in Xero Flor versus Poland case, and the decision will be given by the European Court of Human Rights. So I guess the claim made by my friend that, legal positivism, you can do nothing, can be, I think, will be practically verified, and we'll see whether the status of the Constitutional Tribunal will be verified on the international level and how it will work in practice. Thank you.
If I may add to this, this legal positivism in my case, I'm in the room of the ombudsman still, means that basically the judgment is published. And so whatever we think, it is published and it has a normative value because of from the moment of the publication. And that's the problem, that you may think anything about this judgment, but as long as it is published, you do not have any remedy against it, to be honest. Okay, now Kristaps wanted also to comment. Should just make a short comment to those questions. And then
yeah, I just wanted to make a brief comment on Professor Sadurski's question. I think I agree with Professor Nussberger that pilot judgments is probably not what moves the European Court towards Constitutional Court, but what could be moving it there is the new procedure of advisory opinions. Because the difference between the European Court as dealing with specific cases of simple individuals and constitutional courts as dealing with global questions, that's exactly the difference between individual complaint and advisory opinions. So if more states were to be using it more efficiently, then the European Court would be moving in the direction of European Constitutional Court.
Good, thank you very much. Now, as I said, we have the second set of questions, and the first person is Professor Michał Balcerzak from the University of Nicolaus Copernicus in Toruń. Michał, floor is yours.
Thank you very much, Adam, and I wish to congratulate, first of all, the organizers and the panelists. Very intellectually stimulating seminar. I have a very short comment and also a question. Professor Nussberger started her presentation from this excellent, legend or anecdote about the miller who had this dispute with Friedrich II. I also use it from time to time, but I think, Professor, you have not tell us, you didn't tell us how it ended. Wasn't it so that it was the Miller who shouted that there are still judges in Berlin, right? Es gibt noch Richter in Berlin. And this is sometimes what we also shout towards Strasbourg, that there are still judges in Strasbourg that we count on. So I was, so to say, this recalled me of some issues when you mentioned that legend. But actually, my question and comment is of the following nature. Sometimes we seek for solutions. We try to we try to fix things if something doesn't work. Some of us would agree that over the last years we do have issues with the rule of law in certain areas of Europe and elsewhere. Now there are various ideas how this could be fixed, and of course, in Strasbourg and other jurisdictions, other courts are also in our minds. But now I want to address this, or at least to share this thought. You know, in this strive of regulating and fixing, sometimes we try to add some normative content, to add something. You know, 8 years ago, Council of Europe and the states of the Council of Europe wanted to amend the convention, Protocol 15. They wanted to change something in the preamble. As we know, finally, all states have ratified. It will enter into force after 8 years. And there was this minor changes regarding subsidiarity and so on. Now, my question is, do you think it is at all necessary or feasible, or even does it make any sense to think about some changes, some normative changes? Because, you know, another soft law instrument is also an idea. But what if this is the way? If we would think about introducing some added value and some normative value, I was wondering, do you think it is at all an option? Of course, you know, when you see how long it takes to introduce changes into international treaties, it is disappointing, and it might be discouraging. But I don't know. Maybe you would have some thoughts about it. So once again, congratulations on this excellent seminar, and I will stay tuned.
Thank you, Michał. Thank you very much for your question. And now, Professor Konstantin Zektiarow from the University of Liverpool wanted to take floor. Konstantin.
Thank you very much, Adam. Professor Nusberger, thank you very much for a wonderful presentation. And first, I have two quick questions, if I may. First of all, like we all talk about rule of law, this and that rule of law should be applicable to the contracting parties. But the question is, does the European Court of Human Rights itself complies with the standards of rule of law in its judgment? Is it certain? Are its judgments consistent, etc.? And my second quick question, and this is where I am really sorry, I would have to slightly disagree with you and my friend Kristaps. I think that, and agree with Professor Sadursky, I think that pilot judgments are a sign of constitutionalism. They allow the European Court of Human Rights to formulate general principles, general rules applicable beyond individual cases. And this is, for me, and this is one of the signs of constitutionalism. And it is more important that it's the court itself came up with this structure, and not the contracting parties. And if we compare that to advisory opinion, and that's where I agree with Kristaps, advisory opinion obviously can be sign of constitutional principles. That is coming from the contracting parties, which adds some external legitimacy to the whole idea. So my question on the basis of all this discussion is, well, do you think that the court can act as a strategic actor, as a strategic constitutional actor pushing European public order in Europe? And does it have legitimacy to do that at all? Thank you very much. Amazing, fascinating presentation. Thank you.
Thank you very much, Konstantin. Now I would like to ask Mr. Iver Orsztawik from the Rafto Foundation for Human Rights from Bergen. Iver, floor is yours.
Thank you. Well, I'm meddling in here as a philosopher by education and as a human rights activist by occupation. I'm I would just like to raise the question, I mean, which I think is a problem in our public and political advocacy for rule of law, to explain what is ultimately protected by it. Express a core idea about that. And is it not what we see, what I think we presuppose, most of us, more or less in agreement, a shared minimal conception of justice, including some version of the idea that apart from the specifics of any case, the interpretation of law and the conduct of legal proceedings must both treat and be accountable to citizens as equal members of whatever community is constituted by certain laws, the European community or a national community, or some more local entity. And arbitrariness is a problem precisely because it violates this equal respect on the one hand, and because it undermines accountability on the other. And if rule of law is to be seen as a critical value in a democratic society, I think, hard as it might be, that we need to provide this kind of some kind of substantive anchoring in justice as understood by ordinary citizens.
Okay, good. So that's it, yeah? That's it, Ivar.
Yes, that's it.
Okay,
what do you think about it?
Okay, thank you very much, Ivar. So I have a last question from our participant, Mr. Hamid Ladjevardi, is asking like this. I will read it. Justice can be defined as the administration of the law or authority in maintaining it. And it could be also defined by the Oxford English Dictionary as based on or behaving what is morally right and fair. So the question is, how do we describe what is morally right and fair? Please comment on how can we deal with what is just or proportional, which changes through time and culture, and how special interests can create rule of law to their advantage. How does legal systems deal with these challenges? It is a pretty philosophical question, but maybe you will try to answer it. And just, last question just from me, like personally from me, to Professor Nussberger. What do you think about using Rule 39 and interim measures to rule of law cases? So for example, to judges that are facing some disciplinary proceedings or relevant proceedings aiming towards kicking them out from the judiciary. Is it the case for the Court of the Human Rights in Strasbourg to use Rule 39 in that context? So we have altogether, I think, 5 questions. So Professor Nussberger, I didn't promise you that it is easy to participate in that webinar, but you are a great expert, and for sure you will manage to get through all those questions. Thank you very much. Floor is yours.
No, it's really not easy, but just to say first, it's so funny because I see only these, for many of you, I don't see the photos, but just the nameplate, or sometimes not the nameplate. And it's so nice that I see friends popping up and asking questions. Just to say that before coming to these very difficult questions. So I start with the last one by Adam Bodnar. That is extremely difficult. I can answer on a theoretical and on a practical level. On a theoretical, Rule 39 is something that is a competence that was not given to the court really by the member states, but it's a competence it developed itself. We all know this development, and at some point, the court, also in reference to the Inter-American Court, developed this approach to say when we have the most basic rights and it's always related to life and health, then we must jump in, otherwise it's not effective. And out of this idea of effectiveness of human rights protection, this was developed. It was accepted by states, and based on international law, we can say when states applied, accepted, it has now it's a standard that can be applied, and is applied every week, I don't know, 20 times. Now you ask about judges being kicked out, where it would be extremely important to have an immediate remedy, because if they are kicked out and for years they cannot judge, sometimes it's already too late with a age limit, what we had quite often in Hungary. But even worse than for the individual is the fact that you have a chilling effect on the judiciary itself if you have a judge waiting for years for a judgment. So in this sense, if I apply the effectivity principle, I would immediately come to the conclusion that I say, yes, it's also these core cases for the court, because if judges, justice system doesn't work, the whole human rights protection system doesn't work. So you have to provide the fundament, and you have to provide it in an immediate manner. I can say that as being an ex-judge. I can say that it would be really the right thing to do. If I were still sitting on the court, I would still be reluctant to do it. Because if you develop, it's a huge step forward to develop it, because right now it's clear it's about health and death. Yeah, it's life and death, and it's not about other issues. I know, we all know in this Georgian case, it was opened up to a certain extent, but that was the only case. And the court then said, well, in extremely important cases. It's a question in of the acceptability of the actions of the court. The court has to, the court is weak, and the court is weak in based on the tools it has, but it's strong if its judgments are accepted and if it's implemented in the country. So it's just a risk the court takes. It's the right thing to do, but it's a risk, because if it's not implemented, if it's not accepted, it will lose authority. And we have seen now in the Navalny case, for the first time ever, the court used Rule 39 to ask for freeing somebody. It's not applied, it's not implemented. And for a court, and for a court like the Strasbourg court, it's extremely important not to act in the air, but on the ground, and to be accepted. So I would not know what I would do now if I were still on the court, but I would be, it's like schizophrenia, because I see so good arguments for one side and I see so good arguments for the other side. I'm sure that you will be not happy with this answer, and as long as you are a judge, you have to give a definite answer. Now I'm a professor, and professors can just tell you there are good arguments for one side and good arguments for the other one. It's a crucial question. It's a crucial question indeed. Now coming to the very philosophical question, actually two questions were philosophical. The one you read out was about, if I understood correctly, about what is right and what is fair, and can it change? How can we know, and how can it change? That was, I have to admit, for me always an intriguing question, because we have in the jurisprudence of the European Court of Human Rights, or in the jurisprudence of our constitutional courts, we do have enormous changes. And we know that sometimes we said something is black and later on it's white. We have just changed it. One of the most famous example is homosexuality. The German Constitutional Court in, I think it was 1957, accepted criminal sanctions for homosexuality, and now it ruled on the complete equal treatment of homosexuals. So within 50 years or 60 years, the moral approach or the understanding of the society has completely turned around. What can we do as judges to be to give acceptable answers? If we give now the answers of the 1950, they would not be acceptable. If you had given the answers of 2021 in 2050, they would not have been acceptable. That is probably enshrined in this concept of the living instrument doctrine of the European Court of Human Rights, where you cannot, and I come back, arbitrarily decide something in a new way and say, I'm not interested in what I have decided yesterday, but you have to give very well-reasoned arguments why you think that a specific approach in society has changed, like the treatment of children born out of wedlock, or like the understanding of corporal punishment of children. That has changed, and the idea of law and justice within the convention system has changed as well. So my answer is yes, it changes, but it changes in a way where the interpreters of a legal text like the convention have to be step in step with the changes that take part in society. And there I was also asked by somebody about the strategic, yes, that was Konstantin, strategic actor and legitimacy. In this sense, I do see the court as a strategic actor, as it defines those concepts, especially if it changes the approach to one concept and sees it different. It is a strategic actor. And you asked about the legitimacy. That's an eternal question. I think the main thing is to stay in contact with those that are the subjects of this jurisprudence and to be accepted by them. If you go beyond them, they will consider it as ultra vires, and then you will lose legitimacy. This balance is just what it's all about. What our colleague from Norway said, he introduced himself as a philosopher, and I can just sign what you have said. You said, what is ultimately protected, a shared minimal conception of justice, accountability to citizens, and equal application. I agree. I just agree. I can only say that I agree to how you described it, and I think you brought it on a philosophical level. And coming back to Konstantin, the second question about the pilot judgments, yes, the arguments you moved forward why pilot judgments are part of transforming the court into a constitutional court are very good arguments. It goes beyond individual cases. The court itself decided for the pilot procedure that makes a court, transforms a court into something different. But still, for me, constitutional justice is one thing more, and that is this leading factor, as we had now with us developing new moral standards, new approaches like surrogate motherhood, showing the way. That is what makes for me the additional factor for a constitutional court, and that is not necessarily linked with pilot judgment. That is why I said pilot judgments might be a step into this direction, but there has to be something in addition. And I also agree to Kristaps that very good reference to the protocol number 16, that there we have these abstract ideas, but on the other hand, it's not binding. So this is a step back from constitutional justice, as in theory, at least, these judgments, at least that's written in the text, they are not binding. Then we had the colleague Michal, I say Michal, it's the
Michał Balcerzak. Michał Balcerzak.
Yeah, it's easier for me with a first name. You asked about potential normative changes of the convention system. Let me just refer a few days or a few weeks ago, there was a German author, Ferdinand von Schirach, and he published a booklet that is called Jedermann, jeder Mensch, every human being. And he invented 6 new rights, like the right to truth, being told the truth by the authorities, the right to a safe environment, the right to digital, not to be dictated, not to be under the rule of algorithm. So he invented 6 new rights, and he said, look, that is the vision for the 21st century, and all these rights should be adjudicated on the European level. That's a nice idea. Still, I think it's absolutely irrealistic that our 47 countries would come together, and you mentioned Protocol 15, which is a tiny small step, and to go such a huge step to grant new rights. I don't see the possibility. I think we have more a right skeptical era. It's not like in the 1950s where we had an openness for giving rights to people. Nowadays we have a right skeptical era. That's my understanding. But We just had a conference with a court on interstate cases, and there I made concrete proposals how the convention should be changed, or small changes, in order to adjudicate interstate cases in a more effective way. For example, to have a direct admissibility to the Grand Chamber, like in Protocol 16 cases, and not to go first to the Chamber and to lose 2 or 3 years. Or to make states bringing cases to interstate complaints pay for them, pay specific lawyers, so that the costs are not on the budget of the court itself, and it's slowed down with adjudicating individual cases. So there, concerning these procedural questions, I would hope that there is some scope for change, some possibility for changing to the better. But concerning the substance, I would be pessimistic. I don't think that there is an openness right now, especially because politicians are afraid of losing their power to decide, because judges decide. Thank you.
Thank you very much for answering those questions. And the question is to Barbara and Kristaps. Would you like just to have very, very short comments on those questions?
I mean, the question, the last one about justice is such a broad, I think we will not be able to cover it fully. Since we are in the right skepticism era, I would express just a justice skepticism thought I was learned when I was in my high school. I was taught there is no justice at all because you cannot define such. So having that in mind, I think we have a huge amount of job to do if you want even to try to define it. Thank you.
Okay, and Kristaps?
Yeah, I would like to comment on the question of Professor Bartoszak. I don't frequently quote Justice Scalia with approval, but he said, Constitution is not meant to facilitate change, it's meant to impede change. And the same goes for international treaties. There is a reason why amending them is so difficult and so complicated. And that reason, of course, is legal stability and ensuring legal certainty. And I think one thing that helps in this regard is actually the living instrument doctrine employed by the European Court, because the European Court is milking out the existing text of the convention to a great satisfaction in many respects, including, by the way, a few of the new rights that Professor Nussberger mentioned. For instance, not being ruled on by algorithms, that clearly follows from Article 8, for instance. So yeah, so as constitutions, the international treaties are and should be very difficult to change.
Fantastic. Okay, as the last point of today's discussion, I would like to ask Professor Nussberger for just 1, maximum 2 sentences of a summary of the whole thing. So like this sentence we will take with us just by, leaving today's seminar. So if you could please, just like, on Twitter, like 240 40 signs, letters in order to summarize everything what happened today. Professor Nussberger.
Well, there's a famous quotation of Faust in Faust by Goethe of his assistant Wagner, who said, "Oh, now I'm happy because what is written black on white, I can take it home and feel happy." And I would say our discussion today has shown that you cannot note down in black and white what rule of law is and take it home and feel happy, but you have to continuously try to understand it better and better and to apply it to reality. Thank you.
Wow, fantastic, just fantastic. I couldn't dream about better conclusion of our seminar, and your great, fantastic contribution to the discussion on rule of law. Thank you very much for this, because we had this first meeting concerning sociology of law. Today we discussed about philosophical implications and the perspective of the European Court of Human Rights. Next time we'll talk about the European Union law. On Thursday, 29th of May, we'll have a discussion on this. So thank you very much for agreeing and for being with us and for answering all those difficult questions. And I would like to ask also, I would like also to say that this webinar, in my opinion, is a great introduction to 19th of May. And why 19th of May is important? Because on this date, we'll have a hearing before the Grand Chamber of the European Court of Human Rights on the case of Jan Grzenda against Poland. And it rarely happens that ECHR is organizing hearings in Polish cases. Last time it was 7 years ago in the CIA rendition case. But this is a very interesting case because it is not only about the judicial independence. It is not about independence of a single judge. It is about independence of the member of the National Judicial Council, so an authority which is responsible to oversight the judicial independence in Poland. So very interesting and element of a discussion, I think having a huge impact on the whole discussion on the rule of law in Poland. So let's treat our today's discussion as a little bit like the scholar introduction to what will happen on the virtual Strasbourg soil on 19th of May. Professor Nussberger, dear Kristaps, Barbara, I would like to thank you very much for your participation. I would like to thank all the participants in our discussions, those who are with us on Zoom, on YouTube, who decided to make oral or written questions. Thank you very much for your great contribution. And right now I would like to pass the floor to Mr. Dr. Filip Cyuńczyk from SWPS University, who helped me to organize this event and basically who also helped to establish this great cooperation with Riga Graduate School of Law. Filip, floor is yours.
Thank you very much, Professor. 2 hours passed by very fastly, so I will try to say what I want to say very briefly. Thank you very much for all the participants, and I will just repeat what I said after the first seminar. We just showed that even via internet devices, we are able to still able to be university, so the global community of knowledge. And we proved that by today's seminar. We had a guest from Australia, from Germany, from Latvia, from Russia, from Ukraine. It is amazing, and I hope that we'll be able to see each other face to face soon. And I want to also to say thank you for, of course, for all participants, for our panelists, for our keynote speaker, Professor Nussberger, Chapeau bas, for Adam Bodnar, for Professor Adam Bodnar for being a host, and for our irreplaceable staff from SWPS University, particularly for Mrs. Zofia Orly from Marketing Department, and for our great IT department, for Oskar Szeszuła and Rafał Krawczyński. All these meetings are thanks to them. And also I would like to thank for the staff of Riga Graduate School of Law, Director Rasenaya and Marketing Department. It is a great pleasure to be together via internet, and I hope that we'll meet each other in autumn face to face. Thank you very much, and see you in 1 month. Okej, poczekajmy, aż się wylogują i zrobimy